We now proceed to the third and final case on today's docket, Orange County versus Singh.
May it please the court. My name is Greg Stewart with the law firm of Neighbors, Gibble & Nickerson, representing Orange County. The issue in this case is whether the Charter of Orange County may be amended to provide for nonpartisan elections for county officers as defined under Article 8, Section 1D of the Florida Constitution. Under the Constitution, a charter county is granted broad home rule powers.
Before you go into your argument, can you address why the amendment to that provision in the Constitution would not moot this case?
Yes, sir. The Amendment 10, let me address, Justice Lawson, initially what it did do and then what it did not do. What it did do is it prohibited the abolition of those offices, which had been permitted under the prior constitutional provision. It would prohibit the transfer of the powers to another office. It would eliminate the ability to change the length of term of office, and it require that the only manner that they could be selected would be by election. What it did not do, it did not eliminate the ability of a charter government to impose term limits on those offices.
Well, didn't it do one other thing? It eliminated the language you were relying on as the basis for your argument that counties could do the things that you're about to describe.
In fact, it did eliminate that language.
Right.
However, it replaced it with language which is actually clearer guidance as to the ability of a charter county to provide for nonpartisans. In the language itself, at the various ending of the amendment language, it provides that certain prohibitions, things that cannot be done. And the language is change the length of the 4-year term of office or establish any manner of selection other than by election by the electors of the county. The importance of that language is that the constitutional amendment recognizes that the power to amend the manner is still in existence. The difference is, and where it conflicts with the argument of appellees, is their position has been the election can never be altered. But if you have the abolition, then you could have a variety of approaches. This language makes it clear that the power to change the manner exists and continues to exist, but it is now limited to the manner that it is elected. And I would suggest to the court that that leads to the conclusion that that manner is partisan versus nonpartisan.
I'm looking at the supplemental authority, and what's the language you're talking about?
The very last line of our Amendment 10 language.
So it starts the new language, notwithstanding they cannot abolish the office.
That is correct, but the language at the very end that was added says, or establish any manner of selection other than by election by the electors of the county. That is the new language that has been added and recognizes there would be no need to discuss the manner of selection if that had now been deprived from charter counties.
That restricts what the charter may do, but it doesn't restrict what the legislature may do.
No, and I understand that, but because any charter county is limited by, cannot be inconsistent with general law or by a special act approved by the voters. But in terms of whether the charter has express authority to address the manner of selection of these offices, I believe it does.
Hold on, I'm just not following this because that new language is about what the charter may not do. It may not establish any manner of selection other than by election of the electors of the county. Unless am I correct in that reading?
No, it is part of the limitation of the amendment.
Right. So I mean, I'm reading it right. The charter may not establish any matter of selection other than by election of the electors.
The question is, does that, by indicating that you cannot have any other manner of selection other than by election, eliminate the ability to, in fact, make amendments to the election process?
I mean, but you were relying on language that said that a charter may choose another manner.
What would be the rationale for having that language. Previous in the amendment, it indicates that those officers would be elected. This language becomes irrelevant unless it's in the context that the power to amend the manner of the selection.
I really want to understand your argument, but I'm just not following the logic. Your whole argument was based on the fact that you thought Article 8, Section 1D, the language that is now stricken, saying that you could establish another manner, somehow overrode the election laws that clearly expressly preempt the manner of elections. And now we have that language gone, and language that says that a county charter cannot establish any manner of selection. And I can't see the logic of how you could view that as an authorization to exempt yourself from the election code.
The issue, though, is does that language still give authority to a charter government to have
language that says you shall not?
In fact, the manner that the election, it is clear at this point that with the amendment, once it becomes effective, that in fact, it has to be an elective office. That's clear.
What this language really means, and maybe I've interpreted it wrong, is that these officers have to be elected. They cannot be appointed, but it doesn't say what kind of election must take place.
Exactly, and that's the point, that there's no question that under the prior language in this particular provision, there was an option. There was the elective option. There was the ability to abolish the office and select that position by a variety of means. It could be county commission appointed, citizen committee.
Okay, but in the context of the arguments, the argument as I understood it on the other side was that manner of election, when it granted authority by charter to do something different, meant what you're now saying it means. And your counter was, no, that's, I mean, it seems like you're flipping your argument
What I'm saying
completely.
at this point in time is that this new language recognizes that there has not been an abolition of the ability to address the manner of election.
Well, where's the grant of authority to do it?
Well, I would suggest that this is here, this particular language does grant authority.
Well, isn't it this, I mean, I'm looking at that new language, and I actually have, I don't know what I voted on when I voted as far as what I thought we were doing, but, I think to me, the intent of that amendment was to ensure that these positions are elected as opposed to appointed. But what you're saying is they can't make it shorter than its 4-year term, so it says nothing about term limits.
Right.
And then it can, or establish any manner of selection other than by election. Well, the Florida Constitution and the Florida Election Code doesn't define election, this is a friendly question, as being partisan or nonpartisan. So how in the world would the voters have known that just passed this, that they were about to eliminate in those counties that have nonpartisan elections for these positions, a home rule, that they were giving up, like in Leon County, their ability to have nonpartisan constitutional officers?
Well, and I think that
Is that you're the election law specialist, I guess, but I mean, that to me seems that it would have been a deceptive to the voters if they thought that they were eliminating the ability, the very important ability, to have these officers be nonpartisan when they're
and I think we do need to go back to the fundamental authority of charter counties. They have all powers not inconsistent with general law or special law. So whether there is an express authorization that says you may change this.
But isn't that the problem, that general law specifies the manner of elections in Florida?
It does not specify what this court has said in the Telly case is that there's a distinction between the manner that a position is selected and the election process, the method, the timing, the controls for that. And in the election process, that is in fact fixed.
Was that in the context of preemption?
That is in the context of preemption.
It was before there was an express preemption There was express preemption language in the statute, right?
There is express preemption
But there
under
was, the case that you're talking about was interpreting,
Oh, no, Telly was after the preemption language was added. Now, and so this court in the Telly decision made a clear delineation between those areas that would fall within the purview of the preemption and those which deal with the manner. And ultimately, in adopting Justice Ansted's dissent from the Cook case, this court determined that term limits in that particular case was more in the manner of selection, as opposed to the process. And I'll use the process to kind of distinguish. And if you look through the preempted statutes with 97 through 105, there is no general law inconsistency that requires these offices to be partisan elections. And I would suggest that the language in the Constitution does not change the authority inherent to the charter county, that it may do any act not inconsistent.
so that we have an election code that says all elections in Florida will go this way, and it provides only for partisan elections.
That is not correct. Chapter
Well,
105.
okay.
Chapter 105 specifically deals with the issue of nonpartisan elections, sets out a process. It is clear in looking at the election code that it is contemplated that the scope of nonpartisan elections is far broader than just judiciary or school board. And this court, this is not a first impression issue for this court. Back in the St. School Board versus Winchester case and Quinn versus Volusia County, which I think was in the 90s, both of those cases dealt with charter amendments in Palm Beach and Volusia to, in fact, require nonpartisan elections for school board posts. Those cases arose prior to the 1998 constitutional amendment, which in fact made all school board races nonpartisan. So at that time, this court addressed those issues and clearly determined that that was within the scope of authority for a charter county. Now, appellees have suggested that the distinction, at least in the Winchester case, which is Palm Beach, is that that amendment to the charter was done by special act. However, there's a wide variety of ways and methods to amend a charter, by ordinance, charter revision commission, special act. They all are bound by the constitutional grant of authority. And in the Quinn case, the Volusia case, that was in fact adopted by ordinance by the county and not by special act. So this is an issue that has been addressed. Dealing with the preemption issue, the legislature clearly recognizes that other offices should in fact and will be selected by nonpartisan means, and they have a procedure to accommodate those.
Where in the election code does it say that these offices may be nonpartisan?
It does not specifically identify the four or the county offices and saying they can be nonpartisan. But again, I suggest that the issue is whether there is a provision in the statute which expressly prohibits.
Well, it does say in 100.051 that candidates on the ballot are either going to be nominated by their political parties or have otherwise obtained a position on the general election ballot in compliance with the requirements of this code. So that, to me, it seems like you got to either be put on there by your party or go through this election code. And what you're suggesting is some means by which they can get there outside that code, which I don't see as permissible.
Let's talk about school boards. Under Chapter 105, which is the nonpartisan election provisions, school board members, they're placed on the primary election, and they generally are to be decided at that time, but they are deemed under that statute to be elected at the general election, even though they are not actually on the ballot. That's really the same process that's available for these. The question really is whether the election code prohibits those offices from being selected in any manner other than bipartisan elections.
What is the state, how many counties currently have nonpartisan election of their constitutional officers?
I believe based on the amicus of Florida Association of Counties, I think there were 8.
And so if if we agree with the 5th District, all 8 of those counties would be prohibited from having, because that's never been challenged, would be prohibited from having their offices that they've had as nonpartisan for some period be nonpartisan?
Well, and I think that...
Is that correct?
Potentially, that is correct.
Well, how is it not? I mean, if you can't do it, how could anyone else do it?
Well, I would suggest, again, we have had precedent in the past that has addressed this issue and upheld it. There is no difference between the election code, I think, the preemption was added after those cases, I believe.
But I don't, I mean, the issue in what they were preempting is making sure that counties don't have different ways of counting votes, you know, and certainly the interest is in statewide elections. I mean, the state interest in preemption, that was what was at issue in Sarasota Alliance. So anyway, you're in your rebuttal, and I'm just sort of...
Well, and I think as to that point, that they have been operating under the process that is in the election code, those 8 counties. And there's not been problems, there's not been inconsistencies. The election code, read in its entirety,
they haven't been notified by
the process.
They haven't been notified by the Secretary of State that they're in violation of the election code?
They have not. No. I'll give up my time for the rest of the colleagues now.
Excuse me. Good morning. May it please the court. My name is Jack Pelzer. I'm here today representing Rick Singh individually and as the property appraiser of Orange County, and I'll be presenting oral argument on behalf of all the respondents. The fundamental question is whether a county may alter the method, means, and timing of an election of constitutional officers by making them nonpartisan. There's been a false distinction made here, I think, between means and procedures. In fact, means and procedures are synonymous in this context. Where there is a dichotomy is between means and procedures on one hand and qualifications for office on the other. And this court's cases make that very clear. The Thomas case, the Grassi case, DCA opinions from the Cook 1 case that essentially was breathed back into life by Telly, the 8 is enough case. And this court in the Young Democrats case made it very clear that whether or not an office is partisan or nonpartisan is a matter of procedure. And those are matters that are preempted to the legislature.
So is your argument also, I know you're arguing only for your clients, but that the 8 counties that now have nonpartisan elections would have to go to partisan?
Not necessarily, Your Honor. This is a very important point that I think has been glossed over. There's a whole other article in the Constitution, Article 3, Section 11A1, specifically allows the legislature to enact special acts that affect elections in charter counties. That's exactly what happened in the Winchester case and the Quinn case, where those special acts, pursuant to this particular authorization in the Constitution, affected elections within those charter counties. That may very well be the case in Leon County and in the other counties as well.
But you're saying that really not because of this amendment, but because of whatever preceded it, that there was many years in which those elections were essentially outside of the election code, in violation of the election code.
No, Your Honor.
Well, do they have special acts for those?
Well, possibly, we don't know. We do know that it was true in Winchester and Quinn because that was recited as devolution in Palm Beach.
Were those nonpartisan, partisan cases?
Yes, they were. So, whether these other counties have special acts, we don't know. It's not in our record.
And the preemption statute is somewhat new, right?
And that's right. And that was in reaction to the Browning case. And that, to the extent that there was ever any vestigial authority in a charter county to make an office nonpartisan, that statute clearly took it away. We don't think there ever was any such vestigial authority.
What is the interest, the state interest, in having county offices that are there to serve the people and by nature not political? Like, let's just take the clerk of the court. We hope they're not. They have our records. What is the court's records? What is the state interest in having those positions be political, be partisan?
Well, the existence of the state interest, frankly, is a matter of some speculation on our part, but the whole point of Amendment 10 in this instance and the making the offices, elected offices in the first place, is to make these offices responsive to the people. It would be very dangerous, in my opinion, to have one body that both sets the millage rate, sets the tax assessments, and then collects the taxes.
But in the ballot summary, was there anything about that it would eliminate the ability of counties that are home rule charter to have these elected officials responsive to the people be nonpartisan? I mean, I think most of people in this state are so tired of this partisanship. If that was there, it may not have passed. And I'm concerned that we're actually saying that's yes, elected by the people is one thing, but elected in a partisan political manner for those that are having to do not the will of the people, but carry out their duties in accordance with the applicable statutes and Constitution.
Your Honor, I don't recall there being anything in the ballot summary at all about the partisan versus nonpartisan aspect.
Yeah, because I think that would have,
the impact of the Amendment 10 really wasn't designed to affect this case. How it affects this case is by eliminating the language that was the predicate for the county's argument at the trial court and in the district court level, and even up until 2 days ago, that was the grounding of the county's argument as being the source of its authority. And now that source of authority is gone. Whether that was intentional to affect the partisan elections or to affect this case, the language is still gone. The only potential source of authority is in Article 8.1G, the general language for empowering charter counties. The problem with relying on that is it's contrary to other provisions in the Constitution, and it's also contrary to general law. It's contrary to Article 6, Section 1, which gives the legislature the power, not just the power, but the responsibility to regulate elections, because it says elections shall be regulated by law, which we know means law passed by the legislature.
Could you address this argument about the analogy to the school board elections?
Well, the school board elections are specifically provided in Section 105, in Chapter 105, and that's because the school board, an office which was created by the Constitution, was also made nonpartisan by the Constitution in the amendments in 1998. And so when you have an officer created by the Constitution, if you're going to make it nonpartisan, it should be in the Constitution. There are no other constitutional offices created by the Constitution that are made nonpartisan by statute or by charter. So that would be an inappropriate method. And the very same constitutional amendment in 1998 that made school boards nonpartisan also added the language in Article 5, Section 1, which talks about primary and general elections governing many offices, including county constitutional officers. And it presupposes a partisan method of election, because subsection B in 5.1 says that if only one party puts forth a candidate, then the primary is open. It doesn't say, or if the county chooses to make an office nonpartisan, then we're going to open up the primary as well. The Constitution presupposes that these offices are going to be elected on a partisan basis, and if we were to change any of the offices covered by Article 5, Section 1 to nonpartisan, then this whole mechanism no longer functions. It's a foundational assumption of Article 5, Section 1. Also, it's simply not consistent with general law. It's not consistent with the election code. Of course, we have the express preemption of 97.0115, which does not allow any authorization or allow any alteration of the election code, presumably.
Let me ask you to confirm whether or not I'm remembering and understanding the arguments that were made correctly. It was, when it came to 8.1D, it's my recollection and was my understanding that the petitioners, the county was arguing that when it said that the charter could provide for another manner that meant another manner of election. And your argument was that was incorrect, and it was supported by case law, that meant a manner other than election.
Yes, sir.
Okay. So the argument was because it expressly said that they could provide, this was the county's argument, another manner of election, which you disagreed with, that was the authorization for.
That's right.
Okay. And is the new argument is now reversed. They're now arguing because the new language says that they cannot provide for another manner by charter. They're now saying it means what you said it said, and am I correct?
I'm not entirely sure I understood the argument, which obviously all of us heard for the first time today because of the change.
Do we need to have this supplemental briefing based on, because it seems clear to me that whatever the voters did in this case, they've affected the outcome.
Obviously, Your Honor, we would welcome the opportunity to supply any additional briefing that the court thinks is necessary, but there's nothing in that language that was added that says that, specific, took what was an allowance and turned it into a prohibition. There's certainly nothing in that implies that the entire election process, which includes the partisan nature of the office, is now suddenly wide open. And the reason for that is because of all these other things, which are also still in the Constitution. That method of determining elections is reserved to the legislature, and presupposing that these offices are going to be partisan, and also just the fact that the election code itself presupposes that these are partisan elections, and any attempt by the county to change that would be inconsistent with general law and therefore beyond the authority of even a charter county under Section 8(1)G. And Justice Polston talked about some of this, but we have many other points in the election code where these offices are treated as partisan elections. They are nominated by party in Section 97.02129 and 100.061. They are chosen at the general, they all the way back to qualification. They are qualified on a partisan basis under 96.0612. They are chosen from the nominees at a partisan primary at the general election. That's under 100.041. And even the very design of the ballot depends upon the party affiliation of the candidates for these offices. That's Section 100.051, which Justice Polston read, and 101.151(3)A. And we also have the supervisor's amicus brief in this case, which I think eliminates any debate about whether or not making an office partisan or nonpartisan affects the functioning under the election code. So there are many circumstances where this supposed implied grant of authority, whether it be under the language of Amendment 10 or under the language that was eliminated by Amendment 10, would be contrary to both the Constitution and contrary to general law. Chapter 105 does not provide a catch-all for counties to throw in their offices and make them nonpartisan. There is not a single office that is elected pursuant to Chapter 105 that was not made nonpartisan or put into 105 that was not put into 105 by the legislature.
So notwithstanding the Constitution, the legislature could, if addressed by the counties who want to keep their or want nonpartisan offices, could request special laws for their counties to do that?
Yes, Your Honor.
So the issue that there would be a lack of uniformity in counties that have nonpartisan and partisan would not be, would that be supersede what the legislature would do?
That's a matter of judgment for the legislature. And
but can you advance, for our purposes, what the state interest would be in requiring partisan constitutional offices?
Well, other than the general responsiveness that I already discussed, which
well,
is
you're talking about elections, right. But we have...
And as far as the election process itself, having them in a partisan basis as opposed to under Chapter 105 is a significant difference, because electing at the primary election is much earlier in the year, long before the voters are engaged, and historically we have much lower turnouts for primary elections. And so these individuals who are elected to these offices would be significantly less responsive to the electorate. And it's not in the record, but there are, academic studies regarding the impact of special interest groups when there is low turnout. And that's the principal impact of this amendment. And this now
So we should worry about that for electing judges, shouldn't we?
Well,
Let me just, so, given that the other side has been enlightening, come to your position as to what another manner means. Both sides agree that it means another manner other than election. So under the new language, there would be nothing in the Constitution that would prohibit, even by general law, the legislature from making all these all these county offices nonpartisan. Is that correct?
I would suggest if it's going to happen, it's going to have to be in the legislature, because
Either special law, which is specifically authorized,
That's
or
right.
given the way you've interpreted the language that we've been talking about, that's now, it could be by general law.
Right, and that's pursuant to their authority under Article 6, Section 1, and under Article 3, Section 11A1. They can regulate elections, and they can do it by special law affecting the elections within a charter county. So that is the prerogative of the legislature, not the prerogative of Orange County.
Or, as Justice Lawson said, they could put it in Chapter 105 applicable to everyone, right? Just like they have for judges.
Presumably, yes. And to answer Justice Perriente's question, the reason is because we don't particularly like having judges that are that responsive. We like to have them elected, but not necessarily responsive. They're supposed to be independent. With the time I have remaining, I would like to address
Just to make sure, what you were talking about is the setting in the primary. I mean, there's no reason you couldn't have judges elected in the general election.
That's right.
So we're not really, what you said, which was concerning, that primaries are breeding grounds for special interests, and that's what I was responding to.
And it would be a simple act of the legislature if they chose to take what is normally a partisan primary, and where they're having the Chapter 105 nonpartisan elections, and simply say, we're going to have our Chapter 105 elections on the first Tuesday after the first Monday in November, and eliminate that issue and have the higher turnout for those offices. I would like to address the log rolling aspect of the charter amendment in this case, and the ordinance that proposed that charter amendment. This is not a basis on which this court granted jurisdiction, but I think it's an important issue in this case. And as is log rolling in general, it's also important in this case because it goes to the validity of the other aspect of this amendment, which was imposing term limits on these officers. The county admitted in this case that they were required to propose this amendment by an ordinance. And that's the starting point for this log rolling analysis, because Section 125.67 specifies that all ordinances must address a single subject. It doesn't say except charter amendments. It says all ordinances must address a single subject. There are two cases that the county has brought forward in the lower court and in response in this court to suggest that there's something different about ordinances that are proposing charter amendments. The first is the CRC versus Scott case, but I would point out to this court that that was not a case in which the charter amendment was proposed by ordinance. In that case, the charter amendment was proposed by a charter revision commission, which is under entirely different rules. It's like the Constitutional Revision Commission. They're allowed to log roll. They don't have the same, they have a prerogative that a county commission or a legislature does not have to log roll. There is also the Winter Springs case that was cited, I think miscited for this proposition, because the DCA in that case expressly disagreed with the trial court and found that there was but one subject. And having found that there was but one subject, the log rolling aspect fell out of that case before the decision. So wrapping the rules in this instance, this ordinance that proposed this referendum, was subject to the anti-log rolling provisions. And the ordinance clearly was log rolling these two different provisions together. And this is an instance where actions really speak louder than words, because initially Orange County proposed two referenda, one for the term limits and one for the nonpartisan election. And it was only after those ordinances were already passed that they went back and repealed those ordinances prior to the election and passed this new ordinance that put the two of them together. No voter in Orange County had the opportunity to vote yes for nonpartisan and no on term limits or vice versa. That is classic log rolling, and that is reason enough to invalidate the entire ordinance without even getting into the issue of whether there is any constitutional authority for charter counties to make these offices nonpartisan. So for those reasons, we ask you to affirm in this case, both on the grounds of the lack of the county's authority as well as on the anti-log rolling provisions. If there are no other questions, thank you.
Let me address a couple of matters that came up in Pelley's argument. The legislature has, in fact, addressed the concept of other offices being nonpartisan. They have amended the election code to recognize that. There's this discussion that the election code sets forth the exclusive offices that, in fact, may be subject to nonpartisan elections, and that's simply not true. First of all, in the election code under Chapter 97, the definition of nonpartisan office is an open-ended definition. It says any office that is selected on a nonpartisan basis, without delineation as to any particular office. In Chapter 105, the legislature in 2005 amended Section 105.041, which deals with the form of the ballot for nonpartisan elections. And prior to the amendment, that particular statute was specific, that only this ballot applied only to judicial and school board races. 2005, the legislature amended that, eliminated the specific reference, and then made it for all nonpartisan. Further, the legislature has designated numerous offices without specifying them within the election code that, in fact, will be selected on a nonpartisan basis. So the idea that the election code is the be-all, end-all in terms of those offices that can be nonpartisan as opposed to those that will be partisan is simply not true. It has provided accommodations of its process in order to address any nonpartisan office, regardless of the sources, whether it came from the legislature or under the authority of a charter government. The other issue that was raised was the reliance on Article 6, Section 1 of the Constitution. And that's the general provision. And this court has held and has interpreted that provision that that is a direction to the legislature to, in fact, enact the election code to address the method, the timing, and the controls for the election. And that, in fact, is sufficient. That is all it is doing. It is in no way a limitation on the ability to have nonpartisan races. Now, again, the issue here is that, and I think it does go back to the Telley case, and it does go back to Article 8, Section 1G, which deals with the fundamental authority of charter governments. Again, the test is not whether there's an express authorization. The express is whether it is inconsistent with established general law and they cannot coexist. I would suggest that all of the issues concerning the process that is in place for handling of elections for nonpartisan basis and the fact that there are numerous charter-created nonpartisan offices that have in fact been operating under that for many years demonstrates that the election code is meant to provide that flexibility. And there is no inconsistency. And that is the problem that we're dealing with, is that by the arguments that have been made and was accepted by the 5th District, it required that express authority that you have the ability to make these offices nonpartisan. That is contrary to what the Constitution grants to charter counties. And in fact, charter counties have authority to provide anything absent an express, clearly stated, inconsistent general law or special act.
You are now over.
I would,
But I'll give you 30 seconds to,
30 minutes.
I almost said 30 minutes, but I would have been called to account for that.
As to the arguments concerning the single subject and the log rolling, we'll rely on our brief. But we believe that this is a fundamental right and power under charter government. We would ask that you reverse the decision of the 5th District and find that nonpartisan elections are within the authority of Orange County to incorporate their charter. Thank you.
We thank you both for your arguments, and that is the last case on today's docket. But before the court recesses today, I believe it's appropriate for the court to recognize that this is a significant day in the life and the history of our court. This is the last oral argument, the last regularly scheduled oral argument, at which 3 of our colleagues will participate as members of this court. This is really a watershed in the life of our court. Justice Quince has been here for about 20 years. Prior to that, she served on the 2nd District Court for 6 years. That gives her about 26 years of judicial service. Justice Periente has been here about 21 years, and prior to that, she served on the 4th District Court for around 4 years. So she has about 25 years total of judicial service. And Justice Lewis came to the court in 1998 and has been here about 20 years. Collectively, the 3 retiring justices have served on our court for 61 years. Hope I got the math right on that. I believe I did. They have 71 years collectively of judicial service. I want to briefly say something about them collectively and then a little bit about them individually. These 3 justices are people who love this court, and they love our profession. They have always sought to strengthen the court system and to improve the legal profession. They have dedicated their lives to public service. Now, I think it is known to most people that we sometimes disagree, but I think we all agree that they have sought to do the very best they could for the people of Florida as they have served here. On a personal note, I express my gratitude to them for their kindness to me and my family in various circumstances. Now, I'm not going to go through all the details of their individual biographies, but there's one particular thing I want to acknowledge about each of them. I'll begin with Justice Periente, who is the Dean of the Court. Now, what I'm going to say about her is true of everybody, and the things I'm going to say about these justices individually I think are true of everybody else to one degree or another. But Justice Periente really stands out in one regard. Now, all of us work hard, and we take our job seriously. But in the category of zealous application to the work of a justice, Justice Periente sets the standard for us all. Justice Periente is always working, and I think it's fair to say Justice Periente never gives up. And she is a person who brings great dedication and great energy to the work she has done, and that is true all the time. And that, I think it is appropriate to acknowledge. Justice Lewis has many great qualities I could talk about, but the thing I want to focus on here today is Justice Lewis's passion for civic education. And his career here at the court, his time at the court, has been marked by an unending commitment to civic education, in particular, a passion for educating Florida's children concerning our legal system. Justice Lewis founded Justice Teaching, which has had a broad impact on the children of our state. And he has been nationally recognized for his efforts in this arena. Justice Lewis exemplifies in this his commitment to our profession as well as a vision for the future. So the impact he's had in that regard will last long beyond his service on this court. Finally, Justice Quince. Now, Justice Quince was Chief Justice when I became a member of this court, and I succeeded her the first time I was Chief Justice as Chief Justice, and we had a very good transition, and I appreciate that. But what I want to say about Justice Quince is this. I have never seen in anyone a greater sense of gratitude for the opportunity for public service than I've seen in Justice Quince. At the Bar Convention last year, she spoke about it, and I was moved. But what she said there about how much she appreciated the opportunity to serve on this court is something I have seen exemplified in the way she goes about her work, in the way she conducts herself. And it's really, I would have to say, been an inspiration to me. And I am grateful for it. So with that, I acknowledge that all of us who are here have much to be grateful for. It is a great privilege to serve on this court, to serve the people of this wonderful state on their Supreme Court. All of us are only going to be here a little while. It's a precious opportunity. Three of us are leaving soon. The rest of us won't be far behind them, but not too many years from now, we'll all be going. And while we're here, we acknowledge with gratitude to the people of Florida the privilege they have given us to serve them. And as three of our colleagues go forth to other things, we wish you the very best. We know that you will continue to make contributions to our state and to our profession. So God bless you, and we appreciate your friendship, and we appreciate your service to the people of Florida. And if you would like to say something now.
Well, you know that I could never resist a response, but I do want to make sure everybody, since this is public, understands the Dean of the Court only means that I've been here the longest. Doesn't even mean I'm the oldest, but I'm not going to say anything about that. It has truly, Chief Justice Kennedy, having been on this court for a little less than 21 years, I could say that the collegiality on the current court and the friendships with all of you and your kindness in so many different ways has been without equal. And I think that's important as we go forth to understand how important collegiality is and respect for everybody's point of view in the decision-making process. I find it ironic today that we end with 3 cases that have constitutional significance the 3 of us are the veterans of Bush v. Gore, and so we remember a time when the court was embroiled in a 6-week period with deciding some of the most important issues that we could face. But every day in what we do on this court, we understand, as Chief Justice Kennedy said, that we're serving the people of the state of Florida. and we're serving in the capacity of, as the judiciary, not always doing what's popular or what special interests want, but what either the Constitution, the facts, or the law demand. And I am sure that although we may have different views of what a term means at times, that we all understand that that's our first obligation. So thank you, Chief Justice Kennedy. I think the three of us decided we weren't going to have retirement ceremonies here to burden you all and our friends, but I, for one, am so grateful for my time here, and not going to get choked up, but to understand that it's coming to an end. I look forward to watching great things continue from this court. Thank you very much.
I've probably said too much already in the last 20 years, but I'm just getting ready to go out to the field and get back in the trenches and have a whole lot of fun. And I'm just very thankful for the opportunity to have been here. That's it.
And I'd just like to also say thank you, not only to the governors who gave me the first opportunity to be on this court, but to the people of the state of Florida who, in 3 different retention elections, voted to keep me on this court. And so I am very appreciative to all of the people of the state, to my colleagues for years of dedicated and interesting service. And I look forward to serving the people of this state in another capacity in the coming years. Thank you.
All right, well, we thank you all, and the court will now stand in recess.
All right.